Hello, and welcome to this RSA Conference virtual session on GDPR without the hype. I am your host, Brenna Dobbins of RSA Conference. During the session, all participants will be in listen-only mode. At the close of the presentation, we will conduct an question and answer session. At that time, if you have a question, please use the chat feature, which is located in the lower left corner of your screen. As a reminder, this session is being recorded. Following the session, you will receive a follow-up email containing a link to the video replay. The replay will also be posted to rsaconference.com. Today's presenter is John Elliott, Regulation, Privacy, Security, Risk, and Payment Specialist. I would now like to turn it over to John to begin the presentation.
Well, thank you, Brenna, and welcome to everyone, wherever you are and whatever time of day it is for you, whether it's the morning or like me in the UK here, it's the evening. And I'm going to talk about the General Data Protection Regulation, something you probably can't have failed to notice if you look at your LinkedIn or your Twitter feed or the internet. And so I'd like to try and take some of the hype away from it and really cover just the essentials that are going to be really useful to know. I need to start with some quick disclaimers. I'm not a lawyer, so nothing I talk about today will be legal advice. I have a privacy law degree, but I'm not a qualified lawyer, and if you want legal advice, you should go and talk to a lawyer. Also, the views I'm expressing today are my own. They're not any of my clients or my employers. And finally, because this is a European law, it's written in what I would call English, and some of you may call British English. And for consistency, all of my slides are also in that. So in advance, if you're in America, I'm going to apologize for the excess of U's and basically complete absence of Z's. So with that said, what I'd like to do is to try and remove fear, uncertainty, and doubt that you may have about the General Data Protection Regulation. And I'd like to replace that with relief, because hopefully the fear will turn to relief because you'll realize actually it's not as scary or as complicated as people are making out. There will still be a degree of uncertainty. And the reason for this is until the regulation becomes actual law and in effect, and we see how regulators are going to use it, we don't know how big a stick they're going to use on people, or whether they're going to have some really exciting carrots for us. And then finally, I want to turn that doubt into knowledge, because hopefully there'll be enough in this webcast to give you pointers to find out the information you need to know. So my agenda for the next 60 minutes is this. First of all, I'm going to go through a big picture, the who, what, when, where, why, and how, and where, and why, and when of GDPR, just to put it into some sort of context for you. And then I'm actually going to go look at bits of the regulation and sort of summarize it in hopefully an easy-to-grab hold of graphical form. That's going to take about, maybe 20 minutes. I'm going to be honest, it's not that fascinating, but to give that great big picture of what the regulation is trying to achieve and how it's set out will help when we go into the second part, which is the preparation, which answers the question, well, what should you do now? What should you do tomorrow? And hopefully what should you do for the next 10 months, which should give you some really good information. And then finally, we'll finish, as Brenna said, on a quick question and answer session. So if you type your questions in as you're going along, we won't stop and pick them up as we're going along, mostly because I can't see them and multitask at the same time. But as soon as we get to the end, we'll go through this. If there's some very common questions that everyone's asking, we'll come on to those. So, as a regulation geek, whenever I see a new regulation, these are the questions I ask myself, who's trying to regulate me? What are they trying to achieve? What does compliance look like for me? Is it a great regulation? Is it a great thing that I'd comply with anyway? Is it sensible? Is it useful? And is there a mandatory need for me to comply? Or is it like an advisory regulation? And if it is mandatory, what happens actually if I choose not to? Will the police come and knock down my door? What's going to happen? And also then, what will happen to my organization when I do comply? Will there be something bad that happens because it makes me do things in a certain way that affects our business model? And then working out what I'm going to do, trying to work out if there's a minimum value product, or as I like to call it, minimum viable compliance. I don't want to say what's the least I can get away with, but what's the least I can get away with? And the reason I talk about that is that if there was a regulation that said the fence outside your building has to be 2 meters high, we'd all be able to ascertain that that fence was 2 meters high because we could go and measure it. Okay? And we could say, yeah, that's 2 meters high. When we get to privacy regulation or information security regulation, it's actually really hard to say what is compliant. So there's always a degree of subjectivity. So we may have what we think of as being perfectly compliant, but above that we're going to have sort of like, well, we're over-compliant. We're doing too much to be compliant. And below that, well, we're probably okay. We hope we're okay. And the amount of compliance you have, the more compliance you go for, it tends to cost the organization more money. And so, and so you may even also get to the stage where you spend far too much money, the sort of like money no object form of compliance. And I've worked for organizations who've said to me, John, I actually want you to comply, and I want to be no doubt that we're not compliant anywhere, so I want you to, the phrase they used was gold plate it. And I've also worked for other organizations that said, actually, we don't want to do any of this at all. So can we do the minimum that might look very reasonable? That's sort of like hope we're lucky. And every organization will have some sort of regulatory risk appetite about where it is. So where it is they want to be. Do you want to be here? This is an organization that definitely wants to comply with the regulation and doesn't have much tolerance for not complying. Or here where, you're probably going to be okay, and as long as you don't go into the hope we're lucky area. And so hopefully some of the stuff we can talk about today will allow you to find what that point is for your organization. So what I'm going to do first is run through some very big picture context of GDPR, the who, what, when, where, why, how. So who? It's a European Union law. It's a regulation. It's called the Regulation for the Protection of Personal Data. You can see there's a URL there at the bottom. You can download this very exciting document from the internet and read it. It was published about on the 27th of April 2016, as it says there, and it comes into force. I'll come up to that in a minute. It's about regulating the protection of personal data. And you might say to me, well, what's personal data, John? Well, personal data means any information relating to, and this is crucial, an identified or identifiable natural person, or what it calls a data subject. So let's just quickly look at what that is. A natural person is what the regulation calls a living human being. The opposite of a natural person is an unnatural person, I guess a zombie. No, the opposite of a natural person is a legal person, an organization. So if you read the regulation, it says natural person, it means a human being. And when it talks about data subjects, so natural people are data subjects, that means someone whose data you have. So I'm going to use the phrase, I'm not going to use the phrase natural person a lot. I am going to use the phrase data subject. So a data subject is a living human being whose data you have. So it comes into effect on the 25th of May, 2018. So since being published and coming into effect, organizations have had about a couple of years to get ready. So that's about, 11 months, just over 11 months, just under 11 months away for us now. And I was in a meeting at work today, and someone said to me, well, we could do this, and that would look like we were making an effect. We could probably get here by the 25th of May. But actually, it's like, we're on the right journey. It's like, no, the journey started 2 years ago, as far as the regulators are concerned. And certainly in the UK, our Information Commissioner in the UK, who would enforce GDPR, they've said on the 25th of May we're going to enforce it. So there's probably going to be much grey around. Why? Well, the last EU data protection law came out in 1995. Now, I don't know about you, but I didn't have a mobile phone in 1995. I don't even think I had broadband internet. The world has changed massively. Was Google there in 95? Probably not. So the world has changed massively. And so, and also the last time European law came out, it was what we call a directive. And there's a very subtle difference. A directive was implemented differently in every European country. The regulation, as it's published, applies equally. And so there were really, one of the things they wanted to do was to make sure that there was the same European law everywhere. They wanted to strengthen the rights of the individual over their own data, which is what really the definition of privacy is. And they wanted to embed more accountability into GDPR that was in the last data protection regulation. And they wanted to update it for what the world looks like in 2017. And they actually started writing this in about 2010, so it took quite a long time for it to come into effect. why we have data protection regulation in Europe is because, and I feel a bit embarrassed saying this, being in the UK on the grounds we're about to leave the European Union at some stage, but the idea of being in the European Union is there should be no barrier to services delivered anywhere in the Union. So I, in the UK, have the same rights if I'm dealing with a business in France or in Italy or in Scandinavia. I have the same rights about my data. So the reason it's there is to harmonise protection for good trade in Europe, and also to give equal protection of human rights across Europe. So it's an EU regulation, so as I said, that means it's the law in every EU member state, and it will also be the law basically in all the good friends of the EU. So that's the European Economic Area, which is Iceland, Norway, and also Switzerland. There's two key definitions of who it applies to. These are important. Data controllers, it uses the phrase data controllers. That's hopefully all your organizations. Organizations that have a relationship with data subjects and they process their personal data. And secondly, data processors. Organizations, we'll call them third-party suppliers, but organizations that work for data controllers and process personal data on its behalf. And we'll see as we go through and look at the regulations, we'll talk about data controllers. Who does it apply to? It applies to anyone processing personal data in the context of activities of the establishment of a controller or processor in the Union. This is Article 3.1. So I do like showing what the article says because, you know, it's better that you can read what it says as much as my paraphrasing of it. But the paraphrasing is, if you're a business in the EU, right, then GDPR applies to you. Even if your processing happens outside the EU, GDPR applies to you. And then secondly, and this is the more interesting thing, this is the extraterritorial impact of GDPR. The regulation applies to the processing of personal data of data subjects who are in the Union by a controller or processor who's not in the Union, where the processing relates to the offering of goods or services, irrespective of whether there's payment for those goods and services or monitoring their behavior. So what that's saying is, if you target, if you sell, if you provide goods or services to people in the EU, and not citizens of the EU, residents of the EU, people in the EU, then GDPR applies to you. Now, how that could be enforced against you is another question, but the regulation applies to you. If we look at GDPR, it consists of two sections. The first half of it are called recitals, and this is really the regulations saying what we're doing and what we're trying to do. There's 173 of them. And as IT people, we look at those. They're business requirements. And then there are 99 articles. They're the actual law, the rules. And from an IT perspective, that's like the code. And so if you look at it, the recitals sort of give some background and they say how the regulation should work and what it's trying to achieve. But the actual law itself is contained in the second half of GDPR, which are the 99 articles. And I'm going to look at some of those articles. Of those 99 articles, they're split into a number of areas. So 11 of them are just the general principles of the regulation. 12 consider the data subject rights. That's the rights of individuals whose data you hold. 20 look at the responsibilities of data controllers. 3 of those have to do with information security. So if you're bombarded with information security stuff, only 3 articles out of 99 actually deal with security. 7 deal with sending data outside of the EU. 8 talk about remedies when things go wrong. And then 42% are about how it needs to be administered and implemented by member states, about who's the chairman of the data protection board. I mean, just like blah, blah stuff. I'm going to look at the first 3. I'm going to look at the general principles, the data subject rights, and the responsibility of the controllers, because those are things that you actually have to really worry about. So that was the big picture. What I'm going to do now is look at the detail of GDPR, and then we'll go and look at what we can do. So as I said, there are 11 articles, the first 11 articles that define the core principles of the regulation and also contain all the definitions. That's where the definition of a data controller is and a data subject. The core principles are these. Firstly, that whenever you process people's data, it needs to be lawful, it needs to be fair, and it needs to be transparent. And then secondly, that what you're doing with the data should be expected by the person whose data it is. So the principle of transparency of saying to a data subject, I'm having your personal data for this purpose, and this is what I'm doing with it. The third key principle is data minimization, that you only ever have just enough data to do what it is your business or organization needs to do. And the fourth, and this is common sense, the data you keep is accurate. You keep the data accurate, and you only keep it for as long as you need it. And so that's have minimal data, make sure it's accurate, keep it for just as long as you need it. And as long as you need it, could be you might have a statutory obligation, you might have retention policies, but the basic principle is once you don't need somebody's data, you shouldn't have it anymore. That you should process it in a way that ensures appropriate security of data, and we'll talk about security quite a lot afterwards, and also that you can demonstrate you're complying with the regulation. So the principle of accountability, that a data controller needs to be accountable and be able to demonstrate that they're complying with the regulation. The second section, the data subject rights, there are 12 rights that data subjects, i.e., remember, people whose data you have. There are 12 rights. There are 12 articles that describe the rights they have. I'm going to go through them very quickly, and they are this. First of all, and this is the transparency thing, the data subjects have the right, when they give you personal data, that you tell them honestly what you're going to do with it. That they can ask at any time for copies of all the data that you have about them, and that you need to send it to them. And also along with that, your justification of why you have that data and how long you're keeping it. If there's any data that you have that they say is incorrect, they've got the right to ask you to correct it, and you have the obligation to correct it, as the regulation says, as soon as is feasibly possible. This is a so-called right to be forgotten. A data subject can say to you, actually, I want you to erase that data. Now, this is not an absolute right. You know, if you're a bank and you lent money to somebody, they can't suddenly write to you and say, okay, now I've got the money, I want you to delete all the data you have about me. That's not what the right to be forgotten means. But if you don't have a justification for processing it, if it's not part of a statutory obligation or fulfilling a contract, then the user could ask you to delete their data. And they also have the right to ask you to stop doing certain things with it. And a good example might be to stop using their data for direct marketing. They've also got the right to data portability. In other words, and this is a bit like Article 15 to get copies of the data, and this is quite clever. It's saying that actually that you need to give them their data in a machine-readable format. And the best example I have of this is something like an online supermarket, where you shop at an online supermarket every week or every 2 weeks, and they deliver your groceries to you. And then you want to go and try a different supermarket. But you know it's a real pain to create your basket and all your favorites. Well, the right to data portability says that you can go to the first supermarket and say, hey, give me all my data, give me my shopping data for the past 2 years, because I want to go and send it to a different supermarket. So the right to data portability. They've got the right to object to data being processed if they want, and that's particularly true about something like profiling, so the right to object to you, for instance, profiling the user. And then the right not to be subject to decision-making that has a material effect on them done by automated processing. So if the computer, and this is really interesting as we move to more big data, but if the computer makes a decision that creates a material legal effect on someone, they have the right to say, actually, I'd like a human to look at that as well. And the cool thing is that those rights can be exercised by a data subject at no charge. So that you can't make a charge to the data subject for them exercising those rights, and you have to respond to them within a month. I gave a presentation at RSA Unplugged in London about 3 weeks ago. It's on the video section of the RSA website, where I spent probably about 20 minutes talking about the data subject rights. If you'd like to learn more about those, go and have a look at that presentation. And then finally, after data subject rights, we've got data controller or data processor responsibilities. And there are 20 articles that say what the data controller and what the data processor must do. And remember, 3 of those are about security. So Article 24 says you must be accountable and be able to demonstrate compliance. Article 25 says you have to adopt privacy by design. So when you're building systems, you have to have privacy by design in the design of systems. If you're not in the EU, you need to appoint an EU representative if you're a certain type or size of company. And this is where it's good to go and talk to a lawyer and say, hey, I'm not in the EU, I'm dealing with people in the EU, do I need to appoint a representative? Take good care when using third-party processors to make sure that you're doing due diligence on them, you've got the right type of contract in place. and keep records of processing which can be accessible to the regulator at any time. It says you need to do security well, and we're going to look at Article 32, which is the you need to do security well article, in a second. If you have a breach, you need to be able to tell your local regulator, so that's the regulator in your country in the EU. So in the UK, that's the Information Commissioner. In France, it's CNIL. And in every European country, there's a data protection regulator. If you have a breach, you have to be able to tell them within 72 hours you've had a breach. And Article 34 says, if the risk is high, you also need to be able to tell data subjects about some breaches. Now, if you're in the US, you're saying, hey, we do that already, because you have data breach notification regulation. We've not had that in Europe before, so that's the first time it's coming into Europe for us. To do privacy impact assessments when we're doing new formal written privacy impact assessments, so that's data privacy risk assessments. And then finally, that some data controllers, depending on the size and the type of data they're dealing with, will have to appoint a data protection officer. And that's given by Articles 37, 38, and 39. I'm going to look in detail, a bit more detail, at Article 32. And Article 32 is the one that talks about information security. And it says, actually, this is quite hard, isn't it? Let's just do this one line at a time. So, taking into account the state of the art, the costs of implementation, and the nature, scope, context, and purposes of processing, as well as the risk of the varying likelihood and severity for the rights and freedoms of natural persons, the controller and processor shall implement, and here's the key phrase, appropriate technical and organizational measures to ensure a level of security appropriate to the risk. And so basically, if we have a balance here, it says we have to balance what we could do technically that's the state of the art, the cost, and the nature and processing, with the risk and severity for the rights and freedoms of natural persons, data subjects, human beings. And that's great, because that's a risk assessment. I mean, we already do those, don't we? I guess many information security professionals do risk assessments. And on this risk assessment, you know, we do a risk assessment. You probably have a 5x5 grid or a 3x3 grid or a 21x21 grid if you're a really big organization. And we assess the risk of an information security thing going wrong. And we assess it in terms of the financial impact, the reputational impact, and the regulatory impact to our organization. So we already do that, but actually that's wrong. Because if you look at what the regulation says, it says we have to balance the technical organizational measures with the risk and varying likelihood and severity for the rights and freedoms of natural persons, in other words, the data subjects. So when we do our risk assessment is not about the impact on the organization, it's about the impact on data subjects. So if we had something that went wrong, like if we had a breach of data or data wasn't available, how would that affect the data subject's privacy? How would that affect the data subject's physical and mental integrity? In other words, their health and their mental state. And a really good example of that, you will have heard about WannaCry a few weeks ago. And WannaCry hit UK hospitals quite badly. And a number of operations were cancelled and people couldn't get their blood test results. And yeah, so no, people's health was affected. And that was a breach of personal data that actually had a physical material effect on people. And so, the key thing is that when we do our risk assessments actually need to be the opposite. It needs to be a risk assessment based on the impact on data subjects, not a risk assessment based on the impact of the organization. And so continuing with Article 32, it says, it should implement appropriate technical and organizational measures to ensure appropriate level of security, including, amongst other things, as appropriate. And then it specifies some stuff we have to think about. So firstly, the pseudonymization and encryption of personal data. So can we use tokenization or a technique like that so we're not having people's personal data, or do we encrypt it? The ability to ensure an organization's the ongoing confidentiality, integrity, availability, and resilience of processing systems and services. The ability to restore availability in a timely manner. And finally, Finally, a process for gaining assurance, for regularly testing, assessing, and evaluating the effectiveness of our technical controls. So in summary, Article 32 says this. We need to do risk assessments from the data subject's perspective. We need to look at whether pseudonymization or encryption would proportionately give a good risk to the data, would reduce the risk to the data subject. It says, remember availability, integrity, as well as confidentiality. It talks about resilience, so what's our recovery time objective? How quickly could we get the system back again? And what assurance framework do we have? So that's quite a lot to have in a regulation. And remember that I talked about that we have this like zone of compliance. So I want to address the question, well, what happens if we look at all of that and you're sitting there now thinking, gosh, John scared me slightly. What if we just choose not to do GDPR? What's the downside? Remember when I said I looked at regulation? Now, what's the downside if I choose not to comply? Well, here's what the downside is. So basically, if you fail to comply with the core principles, somebody can complain to your local supervisory authority, and you can be subject to an administrative fine of up to 20 million euros or 4% of your global turnover. Also, anyone can complain to a court, and that's the data subject making the complaint, a solicitor representing a data subject, or a not-for-profit body making a complaint, and you can receive compensation for material or non-material damage. Similarly, if you fail to adhere to any of those data subject rights, so maybe a data subject asks you for their data and you just go, no, we're not doing it, you could receive an administrative fine, again, of 20 million euros or 4% of global turnover, or a court could award damages. And if as an organization you fail to uphold those data controller responsibilities, for instance, your security is poor, or you don't notify in the case of a breach, or you're supposed to have a DPO and you don't bother having one, again, you can receive an administrative fine from your local data protection authority of up to 10 million euros or 2% of global turnover. Now, every time I turn on Twitter, I keep seeing people saying, GDPR, 4% of fines would be terrible for your organization. Look, regulators are not going to give 4% of turnover fines for minor breaches of GDPR. Like if you didn't have records of processing, it's not there's an instant for 2% fine of turnover. It's like, okay, it will be proportionate. So general breach of GDPR won't result in those top level penalties. But if you're processing a lot of sensitive data and you choose just to ignore the regulation, that's the time when a regulator will give those really heavy fines. So that's my brief overview to contextualize GDPR. Now I'm going to look at and address the question, well, okay, John, so what should we do today? Or hopefully, what should we do tomorrow? And this is really very clearly from the position of an IT or an information security perspective. If I was having a conversation with the marketing department or the legal department or advertising or customer service or HR, I'd have a different conversation. I'm really doing this from the perspective of people like me and like you who would actually physically go to an RSA conference as well. And so the first thing to do is to sit down and work out really the first thing to do is just do some big picture analysis. And, the first question to ask, and this is a question to go and ask a lawyer, is, does the regulation apply to us? Do we have personal data of data subjects, and does the regulation apply to us? Let's assume it does. So the next thing to do is to sit down and say, okay, who are our data subjects? Who are the people whose data we have? Who are our core data subjects? What type of data do we have and how much of it? And your core data subjects typically for most organizations are going to be customers, they're going to be employees, contractors, people who work for you, and people who used to work for you, and people who have applied to work for you. You tend to have personal data for all those people. And then how much of their data do you have? Do you have a lot of it or do you have a little of it? And do you have any of the special category data? Because in the regulations, certain types of data that if released or a breach of confidentiality would happen, would have a serious effect on data subjects. It's classed as special category data. And that's health records, criminal records, people's sexuality, their religious beliefs, their political beliefs. So it's anything really that would be used to discriminate against people. And then financial data. Do you have any financial data or data that could be used to create financial harm to people? And how much of that data do you have? And then the next big picture thing to do, is to get a catalog of systems and third parties. Do you have a lot of systems, or do you have that data in one system? Is all your HR data in a single system, or do you have it in an application system, a performance management system, a payroll system, an HR system? How many systems do you have that contain the data? You're trying to get a picture for how much data your organization has and how complex it is, which will then lead you to be able to look at basically a regulatory risk assessment for the organization. Does GDPR pose a big risk for your organization because you're processing a lot of personal data and a lot of special category data across a lot of systems, or is it a small risk? Do you have not much personal data, and is it restricted to one or two systems? And the result of that organizational risk assessment should be able to tell you this, which is, where do you want to be when the regulation comes into force in 2018, and where do you want to get to, say, by 2020? In other words, how quick do you need to run to make yourself compliant? What velocity will any program you create need? Will you need a lot of velocity, or will you need a little velocity? And having done that big picture exercise, and I don't know if you noticed, but some of the things are in blue and some of the things are in green. The blue things are things that I generally expect the business to do, and the green things are generally things that people in information security and IT will be expected to do. And I'm going to really concentrate on the green sort of things. So we do that. We get the big picture together, so we know it applies to us. We know who our data subjects are. We've got an idea of the pace we need to adopt to comply with GDPR, and then we start the more detailed work. And so the first step in our more detailed work is this. We need to create a governance framework for GDPR. So we need to find someone in the organization that owns GDPR, that can get budget for doing GDPR things, and that can talk to other managers about why this is probably quite important for the organization. And again, that's a business thing. And that's going to be typically led by, I've seen it led by all sorts of people. The worst people to lead it are people in IT. It needs to be led by, in some organizations, whoever owns the customer data. In some organizations, the chief operating officer or the head of risk. I've seen it owned by the head of finance. So creating a governance framework with how we are going to do GDPR in this organization. And then the next thing, the real IT thing to do, is to work out, taking that big picture of where all the data is. So where is the data? And that's really a case of getting some business analysts and doing some business analysis to work out where the personal data is, and mapping the data flows from when you collect personal data to when you dispose of it. Where do you collect it? How do you collect it? Is it on a website? Where does it go to then? How do we store it? Look at logical systems and physical systems. Work out, if you store data, do you actually have a process for deleting it? Or since disks became really cheap, do you just keep it there all the time? What third parties it goes to? And if you've got a lot of data, do this selectively. Start with where you've identified high-risk data. Data that, if compromised, would create a high-risk to data subject, and then work down from high-risk data to low-risk data. So that will give you some data flows in an organization. And this exercise might take you 2 or 3 months. Ideally, get some business analysts who understand the systems and how systems communicate in your business. The output of that needs to get then fed back into the business, into the legal team, who will check that all the processing you're doing is fair and lawful and allowed under the Act. And I'm not going to get into what makes processing fair and lawful in this presentation, because I'm looking at it from the IT perspective. But, it's things like, do we have a reason for processing that data? Is there a statutory obligation? Do we have to do it for a contractual reason? Or do we do it because we ask the user for consent? So the legal will need to do those checks. And then as a result of that, they may well update some policies. They may well update their privacy policy, how they communicate things to data subjects. And the business may also at that side decide to appoint a data protection officer. So having done that, having checked whether the processing is lawful and allowed, that will then take us to the next step we need to get involved in, which is what I call deleting unwanted data. Because there's going to be 2 sorts of unwanted data we find. We're going to find data we don't need because we have lots of duplicates, because we took copies of data and moved it from system to system. We'll find old systems we no longer use. that have got data in that we can just get rid of. We find, and if you're a developer, some of my best friends are developers, but developers do this thing which I call a just-in-case backup. We're going to make a change to something. Let's just take a quick backup of the main production database just in case something goes wrong. I tend to find you find a lot of just-in-case backups that should be deleted. And then based on your business analysis of should we be doing this and do we need to do this and do we have the right amount of data, you might have to do two sorts of deletions. You may have fields in systems where you copied data from one system to another system, but you don't really need the data in the system. So you might need to delete fields, and that can be really hard work if the system that's talking to that database actually expects a field to exist. So that can take quite a while to do. And then secondly, you may have to delete records that the business has decided is no longer required, that is beyond or past the data retention time you should have. So there'll be quite a big data deletion exercise to go through. And what next? What comes after the data deletion exercise? Well, hopefully then you're left with only data that you have a legal reason for processing and that you need. And now it's time to go and do the favorite thing of information security people, which is do some risk assessments. So we look at that data and we do a risk assessment and we say, what would a breach of confidentiality, integrity, and availability and our ability to be resilient, what effect would that have on a data subject? And what third-party risks are there? What third parties are we using? Do we have the right contracts in place with the third parties? Are we happy with the security of those third parties? So that will lead us to doing a risk assessment. During that, we might discover we've got some people processing data outside the EU. So we're going to go and talk to the legal team and ask them to deal with that. And then the next thing to do from our perspective is to work out how we're going to respond or whether we're going to respond to all those data subject requests. So remember, we talked about the fact we've got all these data subject requests that data subjects can make of us. How are we going to respond to those? How are we going to give people copies of their data? How are we going to be able to erase data, to restrict processing, to let people object to automated processing, to correct data? If we copy data from one system to another, how are we going to do that? And that will then lead us to what I hope will give us a risk register. So we've done some risk assessments that say this is the most risky data if you have a breach of confidentiality, and we've got some risks of we may not be able to fulfill data subject requests. So we should get a list of prioritized risks. And from that list of prioritized risks, we can decide there are some things we're going to do between now and the 25th of May next year. There's some things we're not going to do between now and then because we just physically don't have time. But we're going to take the high-risk things first. And in every organization I've worked with, you will find some non-compliant activities that will probably have no effect on a data subject if you didn't fix it, that you'll decide to do after the regulation comes into force. You'll do it next year rather than this year because you probably end up having quite a lot of stuff to do. And so from your risk register, you're going to do a plan to do some remediation. And what's that remediation plan going to look like? And that remediation plan is like, well, can we do some more deletion? If we're worried about breaches of confidentiality, can we do some pseudonymization of data? Can we do some encryption of data? Generally, I've found that organizations, this is a really good time to look at your access control, to give everyone least privilege access, and then to look at your privileged users to make sure you don't have too many of those, so that only the minimum number of people have access to personal data. And that will give you probably also a security posture you need for your organization. You might say, well, our security posture is I'm going to do ISO 27001, or I'm going to make sure I adopt the CIS 20 critical controls. So you'll develop a security posture based on the risk and based on the state of the art and the cost of what you want to do. You might decide to use pseudonymization and create different security zones. So you may have a high security zone where you actually keep proper identifiable personal data, and a low security zone where all the data is pseudonymized, so there's no actual personal data there, and then manage the boundary between a high security zone and a low security zone. So you could have an architectural solution to it. So having done that, you get on with your plan. And then I'd also like to suggest that for any of your currently active projects, your in-flight projects you are doing now, you go and do data protection impact assessments or privacy impact assessments for those. And the reason for that is this. the regulation requires you to do this for high-risk processing and in specified circumstances. You can find some really great guidance on the internet of how to do privacy impact assessments or data protection impact assessments. And they need to contain a description of what you're doing, why you're doing it, whether it's, whether what you're doing is necessary, what the risk to data subjects you've identified is, and how you're remediating those risks. And when I talk about it being good practice, it's good practice to do this generally. It's a good thing to do. But also because as an organization, when GDPR comes into effect on the 25th of May next year, you have to do this for some processing. It's a good practice to start doing it, to practice doing it, to having those meetings, to answer those questions. If you're in the InfoSec team, I particularly want you to look at any InfoSec projects that are monitoring your users internally. There's lots of products on the market now that are doing network analytics, workstation use analytics, that are breaking TLS to look for data leakage prevention. Those are all things that will interfere with the personal data of your employees, your colleagues, your work colleagues, your co-workers, and all of those would require a data protection impact assessment. So look at any in-flight information security stuff that's happening in your organization as well as business change. So that's the main plan. There are two things also to do. The first is to create records of processing. So remember that one of the responsibilities in that controller section, the orange section we had, sorry, the yellow section we had, is Article 30 says you need to create records of processing. These records of processing could be requested on demand by the local supervisor in your country. They're essential to be able to demonstrate accountability. And the record of processing, you look at Article 30, I've summarized it here, which says why are you processing it, what categories of data, who are the data subjects, who you've disclosed this data to, who you sent it to, how long you're going to keep this data, and a general description of the technical and organizational security measures. And so that's building a whole set of documentation up that the regulator can look at and that proves you are doing data protection and you're accountable for it. The second thing I'd really encourage you to do is to have an incident response plan and to create incident response plans. Now, I guess we've got incident response plans because we're InfoSec people, but we need incident response plans that deal with what the General Data Protection Regulation calls an incident. So here's its definition. A personal data breach means the breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure, or unauthorized access to personal data, however that happens. Okay? And if you have a personal data breach, that's very carefully look at that. That's a loss of availability, a loss of integrity, or a loss of confidentiality. If you have a personal data breach, you have to notify the appropriate authority in your country within 72 hours. Now, in the States, I know you're used to doing this. We're not used to doing this within the EU. So we're going to notify the supervisory authority within 72 hours. If it's high risk, we need to notify the data subjects themselves. So the way to do that well is to make sure we have a plan and to test the plan and to make sure our legal team are involved in the plan. And so that basically is the stuff that you need to be able, that you can be getting on with now. So working out what the data is, deleting unwanted data, doing some risk assessments, working out how to respond to data subject requests, creating a risk register, which will give you a list of stuff to do, and then do data protection impact assessments for in-flight projects, create your records of processing, and do response plans. And if that wasn't enough, I'd also encourage you to do this, to plan for business as usual next year, because we have all these obligations of abiding by the principles, of responding to data subjects and controller responsibilities that we're going to have to do on an ongoing basis. And that means we need to be able to integrate that into business as usual, especially into change. So here are the key things that I think I'd like to highlight. So any business analysis that involves personal data, one of the questions it needs to ask is, do we have the data? Do we have the legal right to do this with the personal data? We need to start defining what's the minimum data rather than the ideal or the maximum. And as we do new projects, set retention periods and build it in from day one. And if we're taking a copy of data the organization has, work out how we're going to update it if that data changes. So if a data subject says to us, actually the information you've got is wrong, can you edit it? How do we update it? And then how do we, in any new system, support all those data subject rights? How do we support the right to be forgotten? How do we support the right to have the information? Then the second thing, are more systemic. How do we build, we need to build privacy by design or data protection by design into our software development and change lifecycle. We need to start getting it capable of doing data protection impact assessments or privacy impact assessments. So we need to train BAs how to do that. We need to do risk assessments, again, from the principle of the data subject, not just the principle of the organization. So we need to build that into our risk assessment process. We need to make sure we consider third-party risks in more detail. And finally, we need to create some documentation so we've got that accountability. And so we've got those two parallel things to do of what do we do today and how do we integrate GDPR into business as usual. Now, at RSA, we're always keen that any session, whether it's a webinar or a conference session, actually gives you something to go away with. So I hope over the course of the last 50 minutes, there's been some useful information there that will let you go away tomorrow and be a bit more knowledgeable and relieved and less uncertain about the general data protection regulation. Your next steps are ignore the hype from information security vendors. Remember, only 3 articles out of 99 are information security related. There's a lot of business change and culture change that needs to happen in your organization. Tomorrow, work out if the regulation applies to you. Go and talk to the legal team. Then do that big picture exercise. You know, who are our data subjects? How much data do we have of them? How many systems is it over? And how are we going to get compliant with GDPR? What's our velocity? And then use the plan I've given you and think about business as usual. And so now with just 10 minutes to go, I'm going to hand back to Brenna, and we're going to see if there are any. Well, I can see there are some questions, so let's try and answer some questions. Before I do that, just a reminder, I'm not a lawyer. Some questions I won't be able to answer because I know that's a legal question. You need to go and talk to a lawyer.
Excellent. Thank you. Thank you, John. So the first question came in pretty early in the presentation, actually, John. It asks about the GDPR as it relates to employer and employee relationships. Does the GDPR apply in that context? And if it does, what do employers need to do in relation to that employee data that's collected from corporate managed devices?
That's a really great question, and the answer is yes. GDPR applies to the personal data of your employees. And actually, in the recitals, GDPR very clearly says that the relationship between employer and employee is really tricky because it cannot rely often on consent. So a lot of people say, well, what's the reason we can process this data? It's like, well, the employee consents. But in the employment relationship, GDPR talks a lot about how consent be freely given. So it does absolutely apply to data about your employees. In fact, some of your most sensitive data you have may well be employee data because it might be health related, it might be mental health related, it might be appraisals, it might be performance management, it might be their union membership, their race. So all of that information, which is very sensitive, is very much in scope. So does it apply to information you collect from a personal device? Yeah, if it's their personal information, it does. And the first step to do is to do that risk assessment and look at the risk assessment and say, okay, most of that information is quite low risk. Some of the information is high risk. How are we going to protect it? Question about GDPR, about cookies. No, that's a different regulation. That's the Privacy and Electronic Communications regulation. If a web application collects an email from the user, does GDPR? Well, that's a great question. And that's a question I'm going to say you should ask a lawyer because there's a lot of really interesting questions. So my email address, john.elliott@easyjet.com, that's pretty much personal. So my work email address pretty much is personal data. It's my name and it identifies where I work. An email address that you might have at home, like kitten76@hotmail.com, that's probably not personal data because it doesn't really identify you, unless you hold it with a name, like a first name and a last name, in which case then it's identifiable personal information. Adam, your question of natural persons applies to all personal identification of any processing in the EU regardless of citizenship. Absolutely true. It's not about EU citizenship. It's about is the person in the EU. So that's absolutely right. So if you're a US person, you're living in the EU, somebody collects your data, GDPR applies to the data that's collected because it's collecting the data of people in the EU. You'll often see people use the shorthand of citizens, but it's not citizens, it's anyone who is in the EU, which is actually very different to, for instance, American constitutional law, which applies to just Americans. Raymond, the question, will this allow you to ask Facebook or Google to erase all your data? Yeah, it absolutely will allow that to happen, as long as you haven't, for instance, entered a contract with Google to provide some sort of service. So maybe you bought an Android phone directly from Google, and therefore they've got a bill of sale, so you have a contractual relationship. They may have a reason for keeping that data for 2 or 3 years in case you want to say, well, I need a warranty claim, or I want to I didn't get the goods, I want to charge it back on my payment card or something like that. But the behavioral data, absolutely, the right to be forgotten, the right to have data erased, actually was intended to do that. Carmel, previously was changed for requesting data via data protection. Yes, in the UK we had a £10 charge. That charge is now removed, so there is no charge for data subject requests. And actually that's that is one thing that a lot of lawyers are very worried about. I'll tell you for why. I don't know where you come from, but in our country, in the UK, we have a lot of lawyers that like to fish for business, to see if they can make money by creating noise. And a number of lawyers I've spoken to are very worried that because of the fact that data subject access requests are going to be zero charge, a number of law firms will go around getting people's consent to allow the law firm to make bulk data subject access requests and then see what they can do about it. So, yeah, there's no longer a charge. Raymond, under the law, would governments have to delete your data? Well, you could ask them to, but they'd come back and say, actually, it's not an absolute right to have your data deleted. And the government would probably say, well, for tax reasons and all sorts of other reasons, no, we're not deleting your data. But if a government kept data that they didn't have any justification for, that wasn't necessary and proportionate for what they were trying to do, then yes, you would. And I would imagine there'll be some really interesting cases. There's a question about encrypting. Does encrypting your data with key management meet GDPR compliance? GDPR compliance says you have to take appropriate technical and organizational controls, bearing in mind the state of the art and the cost and things. So you may determine that encryption is the right thing to do that. And by all cases, yeah, if you do encryption, you have to do good key management. But would it necessarily meet your requirements? It probably would do. It probably would meet confidentiality requirements. But you'd have to do that from the basis of your own risk profile. Dan, what about people who are stalking you? Are they data subjects? If you keep records of their names, then they're data subjects. They're absolutely data subjects. And Tom, you talked about unstructured data. I've talked a lot about structured data. Yeah, unstructured data like emails and Word documents and Excel files, they may all contain personal data. And, yep, you need to be able to find that and actually respond to data subject requests about those. So all that, what do we call it, end-user computing programs we ran and nobody really paid much attention to? We probably need to go back and look for that. But do it on a risk-based thing. Company I worked with, has insurance information in emails, but that can often be, I've broken my leg, etc. So that's unstructured data. How do you make sure you secure that properly? And unstructured data in email, I think, is going to be a real concern for a lot of people. Raymond, a really great question. When sending data to a third party, how many layers down from the third party are you liable for? All of them, I'm afraid. Although there is actually more impact put on data processors. So if you read the regulation and the article on processors, it says that processors have to be able to provide the same guarantees with sub-processors. But at the end of the day, you're the data controller, you're the person who can be liable. You may be able to reclaim some of that from a data processor, or if a data processor does something really terrible, the supervisory authority now has a direct action against data processors under GDPR. They didn't have that under the previous regulation. The few questions about what about this sort of personal data or what about this sort of personal data, if it's personal data, it applies. A really good question. Can you require the customer to waive their GDPR rights if they want your service? No. Sorry. You cannot ask people to opt out of the rights. But that's a legal question, so going to ask a lawyer as well, because that actually would come into legal advice. But yeah, business email address, phone number could be personal data if you're very, if it's like john.elliott@easyjet.com, that really is. Great question from Neil. What type of security products and technologies would be required to achieve compliance? None. I mean, I know people are trying to sell you stuff to be compliant, but really none. Do a risk assessment, work out your security baseline, then go and choose your products on top of that. The thing you'll probably find you'll invest in more is encryption technology. Kevin, you asked the question, would GDPR be breached by employers watching employees' HTTPS usage by breaking HTTPS because the employee cannot freely decline? I'm going to point you to a link, Kevin. If you do a search on the internet for the Article 29 Working Party, that's the group of information data control, we call them the Information Commissioner in the UK, but the people who regulate data protection. 2 weeks ago, they produced a paper about monitoring employees in the workplace, and that gives you some really good guidance. I don't want to sound like someone who says it depends, but it depends. Privacy Shield and GDPR to be determined. A number of questions about third parties. At the end of the day, you're responsible for making sure that third party, whether it's a cloud provider, has adequate protection. That's your responsibility as a data controller. So you need to start having conversations. But the big third-party providers, the cloud providers, they're very well aware of GDPR and have been doing preparation for this for a number of times, so they will have the right answers for you. But you're still responsible, even though they've backed it off. And I'll take just like one more question, which is Mike. So could I ask Google to delete with me and the searches and everything? Absolutely, you can do. You can ask when this regulation comes into effect, this right to be forgotten, they'll have to do that. It's quite hard work for them. And I will actually, because we're right at the top of the hour, because Kristen has just asked a really good question. Will regulators do regular audits to verify compliance, or only do an audit when there's a claim? If a regulator gets a lot of complaints about an organization, I would expect the regulator to go in and have a look around, to ask for your records of processing, to do a sniff test. I don't think they'll do an audit. I think they'll do a one-day test of, let's look at your accountability records. If you have a big breach, yeah, they'll come and have a really close look at you. And that's really all the time we've got there. So I'd really like to thank you for your attention. I hope you've got something really useful out of this. If you have a friend that you think would benefit from this webcast, remember it's being recorded. It'll be available on the RSA on the RSA conference web pages. Thank you for your time and attention.
Excellent. Thank you, John, for this excellent presentation, and thank you all for joining us for this RSA conference virtual session. You may now disconnect.